For the second session, this session will focus on the link between contracts and litigation. And our moderator for this session is Alfred S. Farah, General Counsel at International Baccalaureate Organization, Switzerland. And the speakers are Alessia Primiceri, Senior Counsel at the Connectivity, Belgium. We have Virginia Lombardo, Senior Legal Counsel, EMEA at Comscope, Belgium. And then we have Rory O'Keefe, Director of Legal Services at Accenture, UK. Now I'll hand over the session to our moderator, Alfred Farah.
Thank you very much. My name is Alfred Farha. I am the General Counsel of the International Baccalaureate, which some people know as the IB. It's a not-for-profit foundation in Switzerland, which provides educational programs all over the world to over 4,500 schools and growing, with the mission actually to bring international mindedness and to the world and better cultural understanding, and in fact leading to world peace. That is the mission. So in that sense, we do have a legal department, and in that sense, I think this session is going to be very interesting because we have the tension between contracts and litigation. Litigation meaning, as one of our previous speakers described it, the path to war, and that's perhaps something that can be avoided by good contracts. So without further delay, I know we're running a little behind on time, and our speakers are aware of it, so we'll stay to the schedule. I'd like to now hand over to our first speaker, which is Alessia Primiceri. I'll let you introduce yourself.
Yes, hi everyone, I'm Alessia Primiceri. I work as a TE, as a legal counsel, senior legal counsel at TE Connectivity in Belgium. And I'm here to present on how to negotiate a good agreement. I support integrated supply chain, so procurement in EMEA and global logistics. So my example will probably tend to be more logistics example, but I hope it works. And if you have any question, you can stop me anytime. So I guess from experience, I think that the first thing that you need to look at when you negotiate an agreement is make sure that you know your business partner. Before even putting a pen to draft any word, you need to make sure that the company that your company is partnering with is you have all the information you need to be able to negotiate a good agreement with them. So try, apart from the normal due diligence that all business people, internal business people would do with any company, like due diligence check and the standard due diligence, credit note and this type of things, make sure that you actually understand what your business partner is selling and what type of products and if it would fit within your company, and you would go, for example, from that to negotiate a better agreement and to avoid litigation. I can make a couple of examples. If you look, for example, at quality and you know that your vendor sends products of good quality, you may not be not so interested to focus the negotiation piece on the indemnification and warranty clause, but you may stress other things. When you go to litigation, you may want to obtain certain clauses that make sure that, for example, if your vendor moves production site from Germany to China to the Philippines, whatever, you have the right to exit the contract without liability, or you get the right to approve beforehand, so that actually, or if there is any change in the manufacturing process, you have the opportunity to say no. On the contrary, if, for example, your provider, you go for a cheap provider, it also happens from time to time, but the quality is not so good, you need to get the maximum information possible as to the failure rate, and try to negotiate the warranty clause instead, the indemnification clause, try to see if you have the possibility to terminate and to exit the contract in case, for example, the failure rate in terms of zero defect is too high, so their products are actually not not in conformity with what you're asking for. So you may change actually your negotiation attitude and concentrate on certain clauses rather than others, with respect to the partners you actually have in front of you. The second point for me, it's really try to understand your own internal business strategy. So I talk as an in-house counsel, obviously, not as an external counsel, but I think it would work the same also for the external counsels. So you need to understand what is basically the strategy of your business. Are they looking for short-term results or long-term results? Are they looking for reduced cost, or are they looking for things like, for example, flexibility? So if I take, for example, the logistics world, I would make a distinction between, are we actually prepared to pay for a higher cost per carton in order to get flexibility, so that if our volume in a distribution center go up and down, we actually do not have to pay extra money on it? Or do we want a lower cost per carton because we have a budget restriction and we want to make sure that we don't pass the budget? A couple of remarks on liability. I know this is a subject that everybody, starts to talk about when it comes to contracts negotiation, and I know many people try to limit or exclude their liability, either capping it or, excluding consequential, indirect, and punitive when it comes to the U.S. damages. But my point is, contract is a give and take. So you have to make sure that if you take a liability, you may want to take certain liabilities, but it has to be calculated liabilities, calculated risks. So I can make an example for my business. What happens usually in the logistics world is that we would typically go to a third-party logistics provider and ask them to manage a warehouse for us. So they would have to commit with the company, a third party, for leasing the facility. And generally, this type of leases are long-term leases. So it can be 5 years sometimes even more, 10 years. So for them, it's a big investment that they do not want to make unless we guarantee in the contract itself that we are going to commit to pay until the end of the lease term, even if we would terminate the contract earlier. So what we would typically do is to try to insert, we would agree to that, but we would actually insert some clauses in the agreement that would say that if we would terminate earlier, we are going to pay our monthly lease cost until ourselves or them find an alternative buyer who is actually willing to take, to replace us and to take the space instead of us. And if they only find, or we only find the space, a provider that is willing to take half of the space, we would continue to pay proportionately. So it makes sense to try to not only limit or exclude your liability, but to try to find a way to mitigate your risks and liabilities when negotiating a contract. Well, I think we sort of already talked about it during the first presentation today, the importance of choosing the right applicable law and venue. My point here is that I've seen so many contracts where you actually start reading the contract, amending the contract, and you didn't even arrive to the choice of law provision. And then you arrive to the choice of law provision and you start saying, okay, maybe we should use this law instead, as if it would be a lottery. This is not the case. You need to decide and agree on the applicable law and jurisdiction before you draft or work on a contract, because otherwise it's going to be a mess. The risks are multiples. You may have jurisdiction under which it will not work because whatever you have agreed before is not enforceable or is null. There may be jurisdiction in which if you have a contract in English, it will just not work because it has to be in local language to be effective. And there may be cases, like I pick up the law that I know the most, Italian law, where half of the contract will not be enforceable. Any jurisdiction, arbitration law, or derogation to the general competency of the court. Any automatic extension, silence renewal of the contract, limitations of liability would not apply if they are not countersigned twice. So you would see a contract that can seem perfectly valid with actually two signatures at the bottom of the contract, and it doesn't work. It's not enforceable. So First choice, applicable law. And, I know this is actually something that it's difficult to choose. We are not expert of all the possible jurisdiction, I understand that. But it can help if you know up front. You can always make searches, contact outside counsels, but make sure you come with appropriate applicable law. I'm a fan of the termination clause. You will see it. I am actually, I would encourage everyone not to underestimate the power of the termination clause. I saved so many contracts by actually inserting clauses that are not immediately visible to the other side, because everybody concentrates on warranty, indemnification, liability. And actually termination is a major point when you want to exit a relationship that is not fruitful. So what I would encouraged to do is to really try to foresee all possible events that can lead to termination, spell them out in the contract, get your way out in order to limit your liability without too many damages if things go wrong. I can make an example. We don't like to make commitments like volume commitments or these type of things, but there are certain global partners that would force us to do that. And there are some cases where the business insists that we agree to it, although I'm not a fan of it. So in this type of cases, what I would typically do is to include some clauses that look like very basic about benchmarking, or you can make your own clause and say, okay, we commit to that amount, but if during the 5-year term to which we have committed, we find another company that applies the same rates for the lower rates for the same services, we reserve the right to exit without paying the rest of the committed volume. That helps. And people usually don't fight it because they see it in the termination clause. They don't think it will ever happen. You know how this works, but it is really important to be able to get out from a contract. I think I'm still within my timing. I talk very fast. I'm pleased. A couple of negotiation tips based on experience. I would never advise negotiation to be based on personal relationships. I know that many business people have worked with other companies long time, and they do have their own contact, and they trust their business partner. But things may change, so you may end up by having clauses in agreement that say that the other party can apply penalties. But because of the good relationship that your partner has with the other company, they basically never applied those penalties. But there will be a day in which your contact at the other company leaves the company or changes idea, and you'll be in very big trouble because they will start applying the penalties. So my point is, forget about personal relationship and forget about it's not in the contract, and it has been verbally agreed, because the judge will not see that. So if you go to court. A couple of other comments on the language of the contract. I know this can be seen as a normal, comments, but I really think that contracts should be clear, consistent, and complete. And this is not the case all the time. I have many cases in which I can ask 3 different people to read a contract and give me their interpretation of it. If they have 3 different backgrounds, they will come back with 3 different interpretations about the same wording that everybody thinks is super clear. So what I would encourage to do is actually, at the end of the contract drafting, ask people within your business that have different background to read certain clauses that are crucial to the contract, to try to make sure that there are no misunderstandings, misinterpretations when something would happen. The same happens with formulas. Formulas normally, people say it's a formula. How can you actually, challenge a formula? You can. You can actually say, okay, this was including VAT, or you can say this was actually meant to include fuel. So try to spell also the formulas out in order to avoid actually possible misunderstanding in the future. The last point from my side in this slide is actually that nobody is obliging you to sign a contract. You should not feel obliged to sign an agreement you don't feel comfortable with. I know that the pressure of the business sometimes can be very high, but you shouldn't. If the negotiation is difficult, the relationships after the business relationship has started will be much more difficult. You'll end up in court, you'll be in trouble. So if you see that your contracting partner is actually not cooperating already at the early stage of the contract drafting and negotiation, I think this is a bad sign. You should actually consider stopping, continuing, and having an agreement in place with that partner. This is actually the last slide for me. I've been negotiating a few agreements by now. I would encourage everybody to make, to be aware of the cultural differences and respect them during negotiation times. There are people that are more passionate. There are people that are calmer. They actually can keep calm, and everyone is different. You need to know who's your counterparty and try to adapt and try to find a common ground to negotiate. One thing that really helped me in the negotiation and also in settlements, I have to say, it's breaks. If you're really in trouble, you need to call for a break. You have to get the people out of the room and say, we need a tea or a coffee, and that really helped, I have to say. It's like at football games. So you need to take your time to develop a 15-minute strategy to completely change the courses of events. This works also in terms of phone conversations. When it comes really bad and the conversation is coming very passionate, you may want to say, I need to discuss this internally. Maybe we can have a catch-up call tomorrow on the same subject. And this will cool everybody down, and it will allow you to take some time. Maybe it doesn't work, but with me it always worked. So I think I would take that in consideration. During negotiation time, at the beginning of my career, I started to say all the time when I didn't agree with something, I cannot agree to this because you have to consider there is a company policy, or maybe I was given a whole explanation of things. And it was difficult to negotiate. At some point, I had enough. And with a French lawyer, I just said, you know what, we don't do this. And he said, fine. I was so surprised. But it doesn't work all the time. It doesn't work all the time. So what I'm trying to say is this type of attitude can actually work. People do it when negotiating an agreement. But it may work with small partners. It may work with one-time partners, not very long relationship, or partners that you can afford to lose. With long-term relationship partners, you need to find cooperation. Cooperation is the ground to have a successful relationship, and eventually, if things go bad, a successful settlement. So think in advance about this and try to work in terms of cooperation, never in terms of conflict with a possible partner. My best advice to conclude this presentation is to try to use the children approach to negotiation. I know something about this. Insist, insist, insist until you get what you want. This is really the best advice that I can give in terms of negotiations. So I really thank you for your time.